Good afternoon. I'm Aletta Genendal. With me is my colleague Bruce and Danae. She's helping with the technical things. Welcome to today's session. The PowerPoints will be sent in Afrikaans and English after the session is completed. We just want to tell you how we're going to deal with the questions. We want to ask you to please use the chat function. We will answer the questions at the end of the sessions, or alternatively email. So please then include your email in the chat function. I also want to ask you guys to follow us on Facebook. We have a new Facebook page. And then we are going to record the sessions, and the whole series of our training sessions will be available on YouTube in a later stage. So it will be available later for you. Okay, so we are talking today about the role of the evidence leader in learner disciplinary hearings. Today is just the overview. We are planning a more in-depth training later on in the year, but today we only have an hour, so I'm going to give you a little bit of an overview of the role that the evidence leader play. Okay. Let me just go on to the next slide. Okay, so the function of the evidence leader is explained in this flow diagram, and I think it can be a very good framework if you want to draft a job description or your duty sheet. You can work from this as a framework. It starts by getting a complaint, or there's alleged misconduct that's reported to the school or to you. Then there's the investigation that takes place. This investigation includes the learner, the witnesses, and the parents. Then there's a gathering of evidence. We then discuss our findings and our evidence with the principal, and we recommend the process that we're going to follow. If it's going to be internal process, or if we need the governing body for external hearing. Then we're going to draft the charge sheet and the notice of the hearing. Prepare for our hearing. We're going to talk about the file that you can put together for the disciplinary hearing. During the disciplinary hearing, we are going to talk about your role with reading of the charges, representing the case, questioning the accused learner, and cross-examining of witnesses. And also, we're going to talk about the preparing of the aggravating circumstances or factors. And then afterwards, the administration of the findings and the sanction, the way it's communicated to the parents afterwards, and then the last step, when our records are brought up to date, the copies of the outcome of the hearings or the recommendation to the department is put on the learner's portfolio. That's a very important step. So this is an overall diagram of the functions, and we're going to talk about every single aspect of this today. Okay, let's look at the profile of the evidence leader. We are trying to move away from the term prosecutor and focusing more on the term evidence leader. You would have noticed in the Zondo commissions, they are also referring to an evidence leader. And you, as the evidence leader, you play a very pivotal role in this process. You are like the captain of the ship. And according to the regulations from the specific provinces, evidence leader should be an educator of the school and should have a SACE number. We know of a lot of schools that use prosecutors or ex-magistrates or advocates as the prosecutor or as the evidence leader, but we have to start moving away from that because it's not allowed. And then as the evidence leader, you should have a very good understanding about the provincial regulations that's published in every province, specifically this General Notice 6903 of 2002 and Circular 74 refers to the regulations in Gauteng. But then we know there's new regulations out for Limpopo. We are very happy for them. The schedule offences and the procedures are more or likely the same than Gauteng and Northwest. So we're very happy. But these documents should be with you on your table, in your hearing, with you every single day, and you should understand and know the contents of it very clearly. Okay, a balance of probability principle. This is something that our parents and our learners struggles with. We have to understand with a tribunal, we use the balance of probability principle. And we explain it by saying that it's likely that is the version. If you look at, for example, a learner that's being accused of dealing with drugs, if there's 3 learners that tested positive for a substance that indicated that they received the substance from that learner, and you found that learner in possession of several bags of the substance, there's on a balance of probability, it's likely that that learner might be dealing in the substance. So it's not that we have to prove anything beyond reasonable doubt. And this should be explained to the parents and to the learners from the beginning of the hearing so they can understand. Okay, so in the investigation, the first thing that's important is that there should be a rule that has been broken, or there should be misconduct. And this rule or this misconduct should be indicated in your code of conduct. It should also be indicated in your schedule of offences from every specific, for every specific province. So if that rule or misconduct is in fact in your code of conduct or in the schedule of offences, then you can investigate it. All investigations have to be conducted without bias. We have to be very careful to not have an agenda or have any personal feelings that's being involved here. We have a process, a due process, that's also recorded in our code of conduct, and we follow that due process throughout. If every step from the beginning, from your investigation to your preparation of your hearing and the procedures of the disciplinary hearing is in your code of conduct, then it's like your constitution, it's like law, and you can enforce it in any way possible. So, okay, now you're gathering your evidence and you put all your documents in the file. Keep nice detailed notes of all the interviews and the learners' reports and your interviews, and keep that together. And then you have to ask every learner, every witness that is involved in the investigation should write written reports. Please remember, this is not an oath, and it can't be enforced, but it's just an accurate reflection of the learner's version of the story. And because it's not an oath, the parents don't need to be present when a report like this is written, but at least everything should. Every report and every testimony of the witness and the accused learner and the victim should be in writing. And then always, from the beginning of the disciplinary process with the investigation to the end, remind all parties that this is confidential and all information is confidential, and we should take care that we don't breach that duty of trust. Okay, and then remember, during the investigation, it's not the disciplinary hearing. You cannot already found the learner guilty. That's the panel. That's the panel's role, to find a learner guilty. The investigation, remember the way you talk to parents and to the learner and to the witnesses, alleged misconduct. No decision can be made of guilt before the disciplinary panel did not make that decision. And then I don't have to tell educators about the Section 28 of the Constitution. Cases, you understand that the learner's, the child's best interest should always be in the back of our heads. And then we recommend to the principal what possible steps to follow. If it's an internal process, is it an external process? And then if there is any measures that should be in place, like suspension, and that you discussed that. Okay, so you're gathering the evidence, and you make sure that in your role as the evidence leader, you only prove or disprove the matter that is raised or the complaint. That's your job, to prove or disprove. And your main source of evidence will be your witnesses that collaborate your facts, and remember, it should be in writing. Your questions that you are posing to the witnesses, and then your documentary evidence, any records. We're talking about academic reports, behavioral records, reports from your educators, visual evidence, your CCTV footage. You can't refer to footage if you don't show it in the hearing. Photos, expert evidence, and site inspections. Make sure this is the platform that you work from. Okay, now if you receive all this information and your evidence, and you feel like you have sufficient evidence on a balance of probability to move forward to a disciplinary hearing, then you can request that to the principal, and the principal will mandate the governing body to arrange a disciplinary hearing. In my personal capacity, I found it best to have a WhatsApp group with your disciplinary committee. It's easier to arrange and to make sure. Remember, in the regulations, it's very clear. You have to have a chairperson and 2 parent members of the governing body. That should be the panel. I see in Limpopo regulations, they call it assessors, but it should be a parent member. Make sure. If you use Marius Botha consultants, we always come as the chairperson. And then there's no issue, but make sure the 2 parents are present. Okay, so remember, you can suspend if you want to minimize interference. Remember, it's about intimidation, the integrity of the testimonies and witnesses. If there's any threat to a learner or a staff member, or if there's any risk of damage to property, we suspend the learner. Look at Section 9 of the Schools Act. And then again, the best interest of the child. If it's not necessary to suspend the child, don't suspend the child. Okay. Certain misconduct, there's an obligation on the school to report that to the Department of Education. Specifically Gauteng, there's a circular dated in 14 October 2013. These misconduct includes serious assault cases with grievous bodily harm, and sexual assault cases and sexual harassment cases. Learner on learner, learner to educator, educator to educator. So you make sure that those serious misconduct is reported. We have an example form available. You can just request that from Adele. Okay, now we have to look at our witnesses. We have to understand that there is a real threat. Sometimes learners are not only intimidated or threatened, but their families. I'm thinking specifically here if gangsterism is involved. So make sure you deal with this in a very sensitive way. And again, you impress on them the requirements of confidentiality. And you tell a witness only enough about the investigation that's necessary for the purpose to get information from this learner, nothing more. And then obviously remember that there's other options available. In my personal experience, it worked best to have a 2-way radio system, and that the witness is in a completely different part of the school. And remember, if the questions from the evidence leader are posed to a representative, either an internal representative like an educator, or it can be a social worker if it's very sensitive information, the question is posed to the representative, the learner answer, and that answer is not recorded. Only the representative can hear the answer. The representative relay the learner's answer back to the panel. And make sure you look at logistics, when the learner, the witness comes in, the parents come in, that there's no situation where they all sit in a waiting room and wait together. Be very sensitive about this. We always get asked about what information should I give the parents before the time? And we get parents that request all sorts of things. And we have to remember that we don't have to give or provide any evidence before the hearing. The learner just need to have enough information to be able to prepare his defense. And if your charge sheet is clear enough, exactly like it's required by the regulations, then you won't have a problem. No other information have to be given to the parents at any stage. The hearing, that's the place where that's the platform, and that's where they will be given reasonable opportunity to examine the evidence from the school. And remember to make copies for the accused learner and the representative so they can view the evidence with the panel. I always make sure I have 3 copies of my evidence, one for the panel and the chairperson, one for my panel, one for my learner and my representative. Okay, so I'm going to only touch on the notice of the disciplinary hearing. I think Danae also covered that in her session, and I think that's really common knowledge by now. It haven't changed, the regulations haven't changed in I don't know how long. Remember, the learner needs to get 5 school days to prepare. 5 school days don't mean Saturdays and Sundays. And if the 5 days falls over the holiday, then we proceed after the holiday. And remember, the nature of the misconduct, the date, the time, should be and refer specifically to the schedule offences and to the code of conduct. Indicate the time, the place, the venue of the hearing. If you have 5 hearings scheduled, don't make all the parents wait from 12 to 2 or to 3, because then you get a parent that's upset before the hearing had even started. In my personal opinion, I feel an hour is sufficient time. Half an hour is not always enough time if you have a learner that pleads not guilty. So an hour time will be sufficient. Okay, so and then you have to provide the rights of the learner. And then remember, you determine the date and the place. Don't get bullied by parents, but be reasonable. If there's real reasons for postponement, then we can look at it and consider it. Okay, make sure that your charges are not vague. I'm specifically thinking here of the term bullying. Bully can be physical bullying, and then it's assault, the charge, or it can be assault on your dignity or your character. That's a Schedule 1 offence. Bully is too much of an umbrella term, and it's hard for schools or evidence leaders to prove prove a charge if it's vague. And okay, write down the time and the date of the misconduct, even if it's not necessarily relevant to the charge. As much information as possible. Even if the time, okay, yeah, I said that. Now we draft the charge sheet. The charge sheet can be combined with the notification. It's not necessary to have a separate charge sheet. And I think if you do it separately, sometimes it's very intimidating to the parent and to the learner. So I think I prefer if it's combined. And then remember to name the specific paragraph or specific schedule when you graft your charges. No duplicated of the same charges. If it's different, if the learner brought dangerous weapons to the school 3 times in that week, then all 3 of the dates and the times will be recorded. It's 3 separate charges, not only 1. And be careful, look at that properly. And like I said, mention if it's Schedule 1 or Schedule 2. And with the chairperson, ask the chairperson to relay how serious Schedule 1 or Schedule 2 transgressions are. And that Schedule 1 offences may lead to suspension and Schedule 2 offences may lead to expulsion. So they understand. And make sure it's on your letterhead. The principal signed it and it's dated, that it looks like a proper and stamped by the school stamp. That always helps. It just looks more official. Okay, so remember, if we want to be fair, we have to give the alleged offender the opportunity to be heard, and we have to give them proper notice. If we don't give them 5 days, the first thing the chairperson will have to do is postpone, in able to give a learner and a parent enough time to prepare. And remember, the notice needs to have all the information about the alleged offence, the time, the place, and the date. I'm just repeating myself here. And then the learner who has been accused must be given the opportunity to present his side of the story or her side of the story and call witnesses. And in cases where a learner has been suspended with immediate effects, if it's serious misconduct, it must be included in the notice, and it can't be more than 7 days. And the learner can't be suspended for more than 7 days. And again, make sure it's signed on the school letterhead, signed by the principal, and dated. I see in most of the provincial requirements or regulations, it's stipulated that the charge sheet and the notification should be delivered to the parent's address, but it's not necessary. We can email it because there is a way to prove that the email was sent and delivered. But in my experience, it's best to have an interview with the parents before the hearing and indicate to the parents how would they like to receive the notification. If there was no conversation with the parent, it can cause problems at the hearing. We get parents that's very defensive, aggressive, because they don't know what's going to happen. If you explain to them the procedures, the misconduct, how the hearing works, that there's a panel that makes a decision, it takes a lot of this anger and aggression out of the picture. Learners and parents will have to sign that they receive, acknowledgement that they receive the documents. That's the important part for the school, that there's an acknowledgement of receipt. Do it in the company of someone, a witness, that they can be a witness to it. And if they refuse to sign, then you indicate it and you and the witness sign there. And then that document gets copied. It's part of your file, and a copy thereof should be placed on the learner's portfolio. Okay. Ladies and gentlemen, remember the Department of Education cannot intervene in an administrative tribunal. It's a SGB internal matter. The only place where the Department of Education gets involved is if you refer or recommend expulsion. And then you send the documents up and they make the decision. So whether the parents run to the department before the hearing, it doesn't matter. They have no right to intervene. I think this is the situation where we get called a lot. Marius likes to send me when there's a lawyer because I like to put them in their place. What if the representative is an attorney? Remember, the Department of Education don't allow legal representation. So that legal representative is just a representative of choice, and they have an in loco parentis role. With other words, they can assist the learner in the plea, they can assist the learner in the presentation of the defense or with their case, they can ask questions to the witnesses. Just mind that the lawyer is not intimidating to the witnesses, sometimes they can do that. And they can assist them with the mitigating factors, and that's all. Remember, make sure in the notifications it's stipulated that they have to give notice to the school if they are planning to use an attorney, so that you know, and you can have someone there to help you through this process. And then if if there's a lawyer involved, they always want to postpone before the hearing. But the day of the hearing stand, they can come and present their points in limine, and then you can consider the points and maybe postpone. But we are not going to postpone before there was not a sitting, like indicated on the notification. And remember, there's no legal arguments during the hearing. Make that very clear. And if you struggle, your chairperson struggle, you have a right to adjourn the meeting and continue in their absence. If they're disruptive or they refuse to work with the procedures, you can also report it to the Department of Education after the fact. But don't get bullied and don't get intimidated. Okay, so your investigation is done. You have to build your case file. In your case file should be the following: your charge sheet, your notice that's signed by the parents and the learner, all your evidence, your written reports, your notes, your witness reports, the debit points reports, your academic reports, previous hearing documents, educators reports, And then your preparation, your questions that you have ready for your witnesses, it helps to write them out. Focus on your main argument. I always say to evidence leaders, have a picture. You have to have a picture in your head about the story, about the incident, and you have to paint that picture to the panel. Remember, if you look at your evidence, don't have the knife there. Sometimes you're dealing with very aggressive learners and parents. It's never a good idea to have the weapon actually on the table. Make sure there's photos, evidence from the dangerous objects or from the drugs. Don't bring the drugs into the room. Take a photo of it and note on that photo. It was taken. It was found in possession of this learner on this day. This was the educator that searched the learner, and this was the witness. And stamp it with your school's name. Make sure it looks like evidence. If you use CTT. CCTV footage, you can also use screenshots with the time and the date, so you can make it easier to for your panel and for your accused learner to view the evidence. You can have the objects there, like I said, just not dangerous weapons, just not the urine from the drug test and things like that. And remember, if you use confidential information like medical reports, remember the POPI Act and remember the confidentiality. That learner, the victim, have to either be present or gave permission for that information to be used. So be very careful and think about the application of the POPI Act. And then keep all the audio, the video, the photos, the recordings all safe on a USB. Make sure you're prepared for any situation. And if we're there in the hearing with your chairperson in your panel, that there's no technical glitch, that we can view the evidence. If you prepare your witnesses and your questions for your accused learner, make sure you formulate your questions before the time. And focus on phrasing the questions in such a way to get the learner talking. Questions, leading questions that in a yes or no answer is not getting us any information. So focus on powerful questions. How can you help us understand why you were there? Oh no, I can't say that. How do we know? How am I supposed to, so what was the role of this person in the incident or this item in the incident? So you can get the learner to start talking. If you ask the learner to give you information, but you come in a not in a defensive, aggressive way, you get the learner to give you a lot more information. If you ask why questions, why did you attack the learner? Then you act out of bias. You're already you're already presuming the learner's guilt. So stay completely away from why questions and ask the learner to tell, what was your involvement in this incident? How did it come that the item was found in your possession? Get the learner to talk. And be prepared for surprises. We all had those disciplinary hearings that we thought was going to be easy, and then everything just unravels. So make sure you're prepared for any possible versions that you might have not considered yet. And have a cheat sheet available for you to give you direction, for you to refer to. I go to a lot of schools, and sometimes you have a prosecutor or evidence leader with nothing in front of them, and it makes hard for what you say, for your words to carry weight if you don't have anything to back it up. So have everything prepared. Okay, as an evidence leader, most of the time your role started way before the hearing and in the investigation. Sometimes you already had a relationship with the learner, you worked with the learner with smaller disciplinary transgressions, or you spoke to the parents. And sometimes everything, it's centralized discipline, everything lands on the discipline head or the deputy principal responsible for discipline. So sometimes in the hearing, there's some aggression and attacks on the evidence leader. Look to your chairperson. He's supposed to protect you. You are not on trial, and you have a right not to be abused. And talk to chairperson before the time. Have a system in place where there's a look or a sign to know that this is going in the wrong direction, and then he must bring it back to the procedure and make sure he understands he needs to protect you at all times. Okay, when you prepare your aggravating factors, this is very important, especially if you want to refer or recommend expulsion. Remember, you present this aggravating factors because you want to merit a harsh sanction. And the common aggravating factors is prior records. And remember, according to regulations, you're allowed to use any prior from grade 1, anything that's in the learner portfolio you can use. And other aggravating factors, look at the misconduct itself, the seriousness of it, the severity of the injuries, and always a good one, the good name and reputation of the school has been damaged. That's always a good aggravating factors. And then always, was there remorse by the accused? We just not confuse remorse and regret with someone that's very sorry that he was caught. So, but if there's real remorse, that's a mitigating factor. And if it's not, it's an aggravating factor. So remember to mention it. Okay, so during the hearing, your role as the evidence leader is to present the school's case. Remind the chairperson to remind everybody present that it's not a personal, it's nothing personal, it's just a specific role that you need to play. Okay, so in this hearing, you're responsible for recording the proceedings. It's, in my opinion, best to have electronic recording made. If there's someone, secretary sitting in, typing the minutes, it's also good, but it's no one can argue against electronic recording. And remember, you are going to present oral, written, and documentary evidence. No, stay away from unnecessary arguments. We hear a lot of those, and then it gets personal. Oh, you're always in my office. It's always you. Comments like that makes it hard for us to have a clean-cut procedures tribunal where a learner is presumed to be innocent until found guilty. So please don't get personal and don't start arguments that's unnecessary. And make sure, remember, it's part of your job description to arrange that the witnesses are available. It's not needed if the learner pleads guilty. Make sure if the learner is not 18, that especially if it's a little bit of a more sensitive case, that the parents or a representative is present if the learner testify. And if you use any evidence, have the laptop, the projector ready and set up already. It's especially if you show CCTV footage, remember to have it on a projector for everybody to see. You are going to be the one to read the charges to the accused when you're asked by the chairperson. And remember to use the term alleged, unless the learner has pleaded guilty. Okay, and then make sure if there's an alternative process with your learner, with your witness, that all the logistic planning, everything is in place, that the radios are there, and that everybody understand how it's going to work. And then it's also part of your role to present the aggravating factors. And remember, if you're going to recommend to the Department of Education for expulsion, there needs to be aggravating factors. And then keep calm. We know it's not an easy task and an easy role, and you get very emotionally invested during the investigation and as your role, specific role in the school. But you really need to stay calm during the process and be prepared for everything, for anything. Okay, so there's other alternative corrective measures to consider as sanctions, or before the hearing or after the hearing. I sometimes refer schools and parents to mediation if I can see that there's a lot of previous issues that's been building up and causing conflict between the stakeholders. So a mediation session can have a lot of power, but get someone in from outside that's objective, or someone from the governing body. And we can always go to plea agreements if the learner admits to guilt from the start, or bargainings. And there's a lot of talk, especially in American schools now, about behavioral intervention plans and agreements. And it's a very powerful tool. If it's the learner's first offense, chances are very good that there's not going to be a successful expulsion. And then you need to have a plan in place to manage the learner's behavior in the meantime. And if there's strict measures in place, it's very easy to control the learner and to manage his behavior and to actually try and to correct it. And if there's no way or effort from the learners or the parent side to correct this behavior, then you write in this agreement that the parent will voluntarily remove the learner from the school. And it's a binding contract, and the learner and the parent and the SGB sign there. So there's a way of managing the system without the department being involved. I think that's a very powerful tool. Things that's important here are like daily monitor, daily plans where learners' behavior is recorded every day. And they become in a little bit of they have no choice. They have to start behaving. And you definitely can see how they are correcting their behavior. Okay, so lastly, remember that a parent have a right to appeal to the Department of Education. And this is about recommendations for expulsions. If they appeal the governing body disciplinary hearing and there's not been expulsion, then it's an internal process by the governing body. If there's a recommendation to the Department of Education, we have to wait for that answer to come back before the parent can appeal. And we know it sometimes takes a while for that answer to come. And remember, grounds of appeal is only three things. It can be that the disciplinary measure imposed was not in line with the grade of offense. And yeah, seriously, go and look at Schedules 2. Remember, you can't recommend expulsion for a misconduct that's not listed in the Schedule 2 of the regulation. So if it's a Schedule 1, or even if it's recorded in your Code of Conduct that there will be a recommendation of expulsion. If it's not written in the schedule, you are not going to be successful. And then obviously if the procedures were not followed, especially with the notification and the proceedings during the hearing, and if there's new information or witnesses available to bring new light or new facts to light that can affect the outcome of the hearing. That's the three grounds to appeal. And you have to remember, if there's an appeal process, you have to allow the learner to attend school. You can't refuse the learner the property if there's still an appeal process, but don't let it drag out for too long. And okay, yeah, the appeals are done by the MEC. There is a described form in Circular 74. You can also ask us if you need a form like that. Okay, let me just see the time. Okay, so I want to run through the functions again, just to summarize everything that was said today. Like I said, your role starts if there's a report of or a complaint about alleged misconduct. And remember that misconduct or that complaint should be recorded in your Code of Conduct and in the schedules from the provincial regulations. You are going to start, as soon as there's a complaint, you are going to start your investigation. Your process entails the learner, the witnesses, the parents. I have interviews, at least 2 interviews with all 3 of these parties. But it's a good thing to have an interview with the parent before the hearing. You explain to them the procedures, how an administrative tribunal works, and that helps the process so much. Then you start gathering all your evidence. You discuss with your principal, or you recommend to your principal the process further. You can then draft the charge sheet and the notice of hearing. Remember 5 school days, and then you prepare your file for your hearing. Remember to put every single document that's needed in that file. Make 3 copies. Make sure that all evidence that you use, there's a copy available for the learner and the representative. And then you start with your disciplinary hearing. Remember, you read the charges, you represent the school case, you question the accused learner, and you present aggravating factors. And then with the finding and the sanctions, remember, with the appeal process, there's not another hearing. It's a written process, an administrative process that will be followed. So, and like I said, they only focus on that free grounds of appeal. And then remember with the sanctions, that the sanctions is in line. And remember, you can remember to put measures in place for the future. We have to understand that our Department of Education look at discipline as not as a punitive process, but as a corrective process. And we have to be able to prove that we've tried some intervention, and that's where that intervention comes into play with sanctions. Remember to refer learners to programs like anger management programs, drug intervention programs, rehabilitation. Remember to make that a part of your process. And then it's also a part of your function to bring the records up to date, to make sure that copies of the outcome of the recommendation is filed in the learner's profile. Sometimes learners leave school in the middle of this process, and then a poor unsuspected school gets a profile with no information. And if they start a disciplinary process, they start from scratch. So think of the next school. Sometimes we want someone else to take our naughty children, but we have to have a paper trail for them to, so they can follow up on that. Okay, so overall, this is the evidence leader functions. Okay.
Okay, so I see there's one question. I have answered the question in the chat function as well. I'm just going to read it. So the question is, feedback from head office about aggravating factors used from too long ago was the school was building a case against the learner. How do we handle this when recommending for expulsion? So I just copy and pasted this from General Notice 2591 of 2001. It's clause 15.13, and I'm going to read it. It says, if the learner is found guilty of the charge, the prosecutor and the learner or the representative of the learner may present evidence before the disciplinary committee relevant to appropriate penalty, including but not limited to evidence of the personal circumstances of the learner, general record of past conduct at the school, the nature and seriousness of the misconduct in question, and the interest of the school community. Okay, so we've indicated here that you have a right in terms of this clause to include aggravating circumstances, which includes the learner's general record of past conduct at the school. This includes all years in the school. Head office cannot change this notice, and we suggest that you appeal against any such finding from head office, and we as Maritzburger consultants can also assist you with that. I see there's another question that came in. May the panel ask questions to the accused learner and a witness, and when does this happen? Okay, so I think it's important to remember that there is a difference between the panel and the evidence leader. It's the evidence leader's responsibility to build the case. Okay, so the panel or the chairperson cannot take the evidence leader's role in asking questions, but the panel and the chairperson can ask questions for clarity. So I think we should just be clear on that the panel cannot be the evidence leader, the panel cannot build the case, but the panel can ask questions for clarity. So if there is a question that the evidence leader, let's say, did not ask, it's okay, the chairperson or the panel may ask the question. Okay, but just refrain from building the evidence leader's case. Okay, so it still remains the evidence leader's responsibility to do all the preparation work and to make sure that the case is presented thoroughly. And then as well, that it doesn't seem as if the panel is biased. Okay, so the panel is not allowed any information beforehand. So just look out for that. Okay, I see. If there's any other questions you can ask. I think we'll remain, or we'll keep the session open for another 15 minutes until 1, but we have run through the entire PowerPoint. We will send you the PowerPoint in Afrikaans and in English at the end of this session. And then if there's any other questions, we will stay online for the next 15 minutes. Thank you very much. Okay.
Thank you so much for listening to me today. And like I said, please remember Marius Weather Consultants for any issue or any legal issue that you might have.
Okay, I see there's another question that came in. It has happened before that a panel member realized that the accused learner is a friend of their child. Do we postpone the hearing or put a new panel together? So the rule here is that the panel should have no interest. Okay, so there must be no interest or no previous knowledge. Okay, so that's the two requirements, is no interest and no previous knowledge. So to be safe, we would suggest that a new panel be put together. But I think to just avoid this is that beforehand, when a panel is constructed, that you just find out who is available. So you will just give the learner's name and surname, basically to say that this is the learner's disciplinary hearing, so that the panel member can inform you beforehand that this is my child's best friend or something like that, to avoid a situation, because it's really not fun if everyone pitches up, the whole tribunal is there, the parents is there, but then we have to postpone and come back at another stage. So if we can just have a look at that, but the requirements is no interest and no previous knowledge. I hope that answers your question.